1.
This Honorable Court of Tennessee is now in session.
Good morning. Before we have Madam Clerk call the case, just a couple of things. If we don't anticipate any technology problems, but if we should have any, everybody just take a deep breath and we'll take a pause and we'll work through it. Call the case, please, Madam Clerk.
In re of Braylee B.
We'll hear from the appellant.
May it please the court. My name is Timothy Webb, representing the respondent. This is an appeal from the termination of parental rights order in the Chancery's Court for Scott County. As the court is aware, termination of parental rights requires clear and convincing proof that one of the statutory grounds for termination exists and that termination is in the best interest of the child. Clear and convincing evidence is, as the court has stated before, evidence in which there is no serious or substantial doubt about the correctness of the conclusions drawn from the evidence. And that statement is key here. The evidence must be, admissible evidence must be before the court. Now, appellant would state that the trial court erred. They don't even need to reach that question there. The court allowed the petitioner to proceed without having satisfied discovery requests made by respondent. Now, the rules of civil procedure permit the discovery of relevant non-privileged information. Now, the respondent had requested certain information that was contained within Facebook messages, which both the respondent and petitioner had stated was the sole method of communication for the 4 months preceding his incarceration. Now, we stated to the court at that time that this evidence was necessary for him to permit his, or to properly prepare his defense. He had made his request more than 30 days before trial, renewed his request at the inception of the trial, and once again renewed that request prior to his presentation of his defense. Now, as I said, testimony by both the petitioner and the respondent show that this was the only method of communication between them for that 4-month period, the important seminal period there. Respondent had testified that he no longer had the password. Of course, he was in prison at the time and he was unable to access it. So therefore, the only manner in which that could be accessed would be from the petitioner.
Counsel, explain that to me. I understand he said he no longer had the password, but that doesn't kind of end things, does it? As far as, I mean, this was his account, wasn't it? That's what you're asking for.
It was his account, yes. And he had stated he had given his password to his sister. Of course, if the sister has become somewhat of a hostile witness during the time period, so it was not available to him. She was able to, and this is not reflected in the evidence, she would have been able to change that to where he wouldn't be able to access, where it would literally no longer be his account.
Well, that's not in the record, though, is it? So
it is not. No, Your Honor, it is not.
Okay.
So
all right. So what he was asking for on this discovery was communications from his Facebook account to the petitioners.
Communication. I'm sorry.
Yeah, and back and forth communications between those two.
Yes, Your Honor, that is correct. And the only way we had to obtain those would be from petitioner. Of course, counsel for petitioner objected at that time and at every stage of this, saying it was a fishing expedition. Now, the trial court ruled that this would need to be obtained through Facebook, and that is not true. Now, in my brief, I mentioned that although it is a criminal matter, State versus Johnson, 538 Southwest 2nd 32, it gives us some guidance here. That case stated, although the defendants cannot obtain the witnesses' electronic communications directly from the providers, which in this case would be Facebook, Nothing prevents them from obtaining that from the witnesses. And this is analogous to a criminal case, and I'll mention this later, in that this is the ultimate sanction for a parent. This is the parental death penalty, so to speak. It is the civil counterpart to the death penalty in a criminal case. Now, even after hearing both parties testify that this was the sole method, the court ruled that she refused to compel the production. Now, she did allow a time period for them to provide that later on, but that was not provided. Now, assuming that the court does not see any issue there, the court erred in finding that the petitioners have proven by clear and convincing evidence that grounds exist to terminate his parental rights. Now, the trial court ruled in its findings of fact and conclusions of law and opinion of the court that the ground of wanton disregard had been proven. Now, in reaching that decision, the court ruled on evidence which is not contained within the record, not properly proven, not properly admitted. Findings of fact number 2 and number 6 state 4 statements. Mentions convictions that are not evidenced by certified copies of any convictions and are not contained within the record, probation violations that are not supported by any reproducible certified copy of any warrant violation that's endorsed by any judge of competent jurisdiction, stating that the respondent had failed to abide by any ordered terms. The court relied upon alleged failed drug screens, which are not connected to any probation violation or any convictions, and incomplete stays in 2 rehabilitation centers without any evidence that he was ordered to complete those as a condition of any conviction or condition of any probation. Now, the evidence as submitted does show that he was ordered to attend a rehabilitation center as part of an order of protection, but the testimony at trial disclosed that petitioner herself violated that order of protection by going to the facility and picking him up and bringing him back home. Now, it is admitted that the respondent did plead to a count of robbery and 1 count of attempted arson, received a 2-year sentence on one, a 5-year sentence on the other. This court should consider the passage of time from that time period to now, as well as the testimony of the respondent that he is not the same person. He is a different person now. Now, as to the willful failure to support, the court based its rulings based on several factors allegedly showing a willful failure to support. Now, the court viewed the applicable timeline as being the 4 months prior to respondent's incarceration. Now, for the purposes of the record, at that time, the parties were married, and they continued to be married up until January the 4th of 2019, when the Scott County General Sessions Court entered a divorce decree and a parenting plan that provided no visitation for respondent, an explicit no duty of support for respondent. This case was heard without him even being present, a parenting plan which provided no parenting time, and in fact required an affirmative duty upon respondent to appear before the court and request for parenting time to be provided. Now, literally, the order says that the parental rights of the father are suspended until such time as the father makes proper application to the court and appears before the court to address the parental rights. So it should be noted here that the parenting plan only contains the signature of the General Sessions judge, does not contain the signature of the petitioner or the respondent. Also to be noted here is that the parenting plan is not incorporated within the final decree of divorce. Now, continuing on, They were married at the time.
Counsel, excuse me, let me ask you here. On the failure to support, if I remember correctly, I mean, you admit in your brief, I think the way you put it was that it is technically met. Is that correct?
I'm sorry, I didn't quite understand.
Yeah, as I recall, I think in your brief as to the ground failure to support, that you say that it is, quote, technically, close quote, met. I mean, is that right?
Well, it's admitted he is being incarcerated for the full length of both before they were divorced and he remains to this day. He will be released on the 27th. And there is a duty to support, yes, but.
So my question though is that's what you say in the brief, right? That it's been technically met.
Yes.
Okay.
Now it appears that since the parties were married at the time of this incarceration, utilizing that time period for a termination based upon willful non-support would weigh against public policy, it seems. While married, that marriage is a union of two people, even if it could be shown that he contributed nothing. And certainly not the case here. This is a logistical fallacy because families with only one working parent, using the strict language of that statute, would have an automatic ground upon incarceration by the non-working parent. So, I stay here. He does have a duty to support. The question is it willful? We would say that it is not. Now, the court also erred in finding that the petitioners had proven by clear and convincing evidence that it was in the best interest of the child for his parental rights to be terminated here. Now, factors 1, 2, and 6 don't apply because they're formulated for cases involving the Department of Children's Services. And pertaining to factor 7, he did admit to drug use. Yes. He also testified that he had made some very childish decisions. He had moved past that and wanted to be a good father. And at this point, I will save my remaining for rebuttal, Your Honor.
That's fine, counsel. You have your time for rebuttal. We'll hear from the appellees.
Good morning, Your Honor.
Good morning.
I don't really know where to start. I'm not really familiar with this.
That's fine. Just take your time. Will you be speaking for both of you? I
Yes.
mean, you'll be the one making the oral argument. Okay. Not that
Yes,
you're
sure.
speaking for both, but go ahead. I'm sorry.
As far as waiting and discard goes, I don't really know how to put this. We're not asking nothing but what's best for Braylee. I have personally asked her myself if she has remembered Mr. Banks, and she has no knowledge of him. And past 3 years, he has been 100% absent from her life, and she has no memory of that. And we just feel like it would be in the best interest for Miss Braylee, because she's safe, she's happy. She only knows life. She only remembers life as she knows it now. And he has a history of violence and drugs, and I wouldn't want to subdue a child back into a life like that.
All right. Anything further, Mr. Webb?
And other than the Facebook thing, I don't understand what is wanting to be seen there. I mean, that's the way we did communicate, but I mean, I don't understand what is wanting to be noted We've I've tried every way in the world before he got put in jail for him to be a father. There's been the first 2 years of her life, he was in and out, even if he was not in jail. I mean, I had to hunt him down numerous of times just to get him to be there. She doesn't know him. She doesn't, I mean, if she had to be put with him, it would probably scare her because she has no knowledge of him anymore.
Anything more either one of you want to say?
No.
Okay, that's fine. We'll hear from the appellant. Will have his time to do rebuttal. So we'll hear from the appellant rebuttal now.
Thank you, Your Honor. Had the court, to mention something that Ms. Webb stated, had the court, or Mr. Webb, had the court not terminated petitioner's parental rights, he would not become the child's custodial parent, much less exercise supervised parenting time upon his release, which will occur on April the 27th. And to apply that standard to a step parent termination and adoption case is somewhat nonsensical. He does state that although he has not had regular contact, he is prohibited from doing that due to the final order, even if he were out today. He did state that he had a meaningful relationship with the child prior to his incarceration and had enjoyed visits with the child when she brought the child along with his mother to the jail while he was incarcerated. And
counsel, you say he's prohibited. You're talking about the divorce order?
Yes, Your Honor.
Well, I mean, doesn't it provide a way for him to obtain visitation?
He must petition the court.
Yes. Has he ever done that?
He has not.
All right. Thank you.
In his incarceration, he has not. As I said, he was incarcerated prior to this divorce being filed. He was incarcerated at the time. He remains incarcerated to this day, will be released April the 27th. Now, in summary, the court should not have even tried this case without allowing petitioner the communications that took place between petitioner and respondent. Assuming this court does not find that would be a valid reason for this to be reversed, the evidence that the court based its ruling on is simply not there. There are numerous references to convictions which are not proven, not shown, not admitted, not present. And in the words of the respondent himself, he stated that he had made childish decisions. He was a different person now than he was then. And one of his statements at trial, in response to a question by counsel for petitioners, if you always judge a person by his past, he will never have much of a future. Even if there is some wanton disregard shown, or if this court sees that those convictions are applicable, not all conduct is irredeemable. We would posit that he is redeemable, that he has shown himself, and he should be given an opportunity. And I thank this court for your attention.
Okay, thank you. Thanks to both sides. The procedure, Ms. Webb, the procedure that will be followed here is we'll take the case under advisement now, and then we'll arrive at a decision and we'll release a written opinion setting out what our decision is, and we will send it to you and to Mr. Webb at the same time. So you all should receive those at the same time.
Thank you, Your Honor.
Well, Madam Clerk, will you please recess court till 1:30 this afternoon?
This Honorable Court of Tennessee is now in recess.
Thank you.